Welcome to U.S. Immigrant Journey, Opportunities and Challenges.
Hello, everyone. Welcome to U.S. Immigrant Journey, Opportunities and Challenges with attorney Edwin Fogum. Edwin is the founder of Fogum and Associates and has spent nearly 3 decades helping immigrants and businesses navigate U.S. immigration law. My name's Sean O'Connor, and today Edwin and I are talking about how high-skilled professionals can qualify for permanent residency through the EB-1A and EB-2 National Interest Waiver, often without employer sponsorship. A lot of details here. Edwin, it's good to see you.
Thank you, Sean. Nice to see you again.
Let's start, at the basic level. What are EB-1A and EB-2 National Interest Waiver, and how do they fit into the broader employment-based immigration system?
Basically, EB-1A and EB-2 National Interest Waiver are employment-based visas. In immigration, you have family-based, employment-based, and humanitarian immigration. And these particular categories of visas are for high-skilled workers and extraordinary ability foreign nationals. And I'm sure we're going to break them down as we go on. What is EB-1A and EB-2 National Interest Waiver? So, yes.
Yeah, for sure. We'll get into that. I'm curious, in these particular categories, what makes them different from the other employment-based paths where, usually you need an employer, like sponsorship or something like that, right?
First of all, EB-1, as I stated, is for extraordinary, EB-1A specifically. There is also EB-1B, but EB-1A for extraordinary ability foreign nationals is for foreign nationals who have established or have extraordinary abilities in the sciences, arts, athletics, education, and things like business. Now, under the regulations, those who have accomplished at a very high level, who have had like an award or prize of an international recognized prizes can immediately qualify. But those who don't have that can still qualify from a list of about 10 requirements. And these include publications, judging others' works, what they've accomplished in way of business, salaries, and so on. And that is EB-1A. Now, EB-2, National Interest Waiver, is different. It's also employment-based, but does not really require that extraordinary level of from the foreign nationals. What the foreign nationals have to prove, of course, is first that their endeavor has substantial merit and is national in scope. Secondly, that they are well positioned to continue that endeavor in the United States. And finally, that the labor certification requirements should be waived. And this is very important because for both categories, that is the big benefit. The petitioner doesn't have to go through the long labor certification process to prove that there are no Americans willing and able to work. And that is waived based on the fact that the foreign national has established either extraordinary ability or that their endeavor is going to benefit the national interests of the United States. So we can look at some other aspects of it, but
this is, there's a lot of sort of terms of art, in this case, extraordinary ability. Is there a clear definition of that, or is it kind of know it when you see it?
Well, it is both. Now, the regulation speaks of sustained and sustained performance and abilities and things like that. But it is a creative endeavor, even though the regulation provides these directives of extraordinary ability and what it looks like. There is also a reliance on case law from the AAO, the Administrative Appeals Office, that actually where appeals go to adjudicate these cases. So yes, it is both. You can see some, but it has to be articulated.
Well, and there's some areas there where, and obviously we know a celebrity, or an athlete or something where you'd see them in the national news or an Olympic athlete, but then there's others who maybe you haven't heard of, but if, they still may have an extraordinary ability that's just not part of our day-to-day conversation. Well, you got extraordinary ability, then you've got this other factor of national interest. National interest, I'm guessing similarly, in my mind, I think, okay, this person who, let's just say they live in Colombia and they're an amazing scientist with a specific specialty, and they're going to come to the United States and contribute to some scientific research here. Is that the kind of thing we're talking about, or would you describe it?
Yes, you're right in some respects, but what usually the national interest waiver aspect is usually placed through the DANASA requirement, right? And of course, the first 3 or 4 requirements are pretty straightforward: advanced degree or exceptional ability, and member of a profession, which most professions can be done. However, the last 3, which I mentioned before, to demonstrate substantial merit and national implication. For a foreign national, that nexus may be a little challenging, but it can be done because there are many things that it could use to show that this will be beneficial to the national interest of the United States. But most importantly is the showing why that petitioner should not go through the labor certification process, why that should be waived for the benefit of the United States, maybe because of expediency, shortage, things like cybersecurity type of things that are required, AI things that are immediately required, and it will not be very beneficial to the national interest of the United States if that petitioner has to go through a lengthy 2-3 years period to get that. But you are right. You can get it from abroad. You could actually petition from abroad if you can document that. And you can petition from within the United States. There are many students in the final years of their programs who may begin to PhD programs particularly and postdoctoral programs who may qualify for even the EB1 sometimes, but mostly for the EB2 national interest waiver.
Okay, so you've got a client who thinks they want to pursue one of these waivers, right? One of these pathways. What do you do to to build a strong case for one or the other? Like what's your approach?
That is a very important question because, as I said, the both of these categories is a creative endeavor. First of all, the credentials of the foreign national and the work they have done in the past should be well articulated. Secondly, testimonial reference letters from experts or persons in their fields who understand the implication of their work. Also, publications, if it is academic, if it has to do with business, the ventures, and if it has to do with athletics, proof of what has been done. And of course, this has to be put through the lens of the regulations. If it is extraordinary ability, through the 10 requirements, and if it is national interest waiver, through the DANASA requirements. So you build a good case by supporting that petition. Substantial documentation, the personal statement articulating the background and having supporting documents with that. As I said, testimonial from experts, and they have publications as well.
Interesting. Yeah. I mean, there's definitely, besides of course, there are certain actual documents that are required, but then, there's an element of human persuasion in this as well, right? You're telling a good story. You need to back it up, but you are telling a good story, right, as to why this person's worthy.
The required documents are usually the U.S. forms. Yeah, basic forms and filing fees, and Of course, right, things like certifications that establish advanced degree, bachelor degrees, and so on. But all the other things that support these are usually some subjective and objective evidence. Objective evidence can be very helpful. For example, if it's in an area that is in high demand and there are urgent requirements for that endeavor, what you could do is you could show that it will be beneficial to the national interests of the United States not to waste time and go through the lengthy labor certification process that is for national interest waiver cases. Now, fortunately, EB-1A presumes national interest, so you don't have to prove it. In the case of EB-1A, if you can demonstrate extraordinary ability, it is assumed that that is beneficial to the national interests of the United States.
Interesting. Yeah. So on the other side of this, right, what, more on the more, I guess, negative side, but like, what are the most common reasons that you've found that, these types of cases end up getting denied?
Usually, what we have seen most of the time for self-petitions, because most of them are self-petitioning, there are no employer, because that's what you want to waive. There's no employer involved and no labor certification. One of the biggest reasons for denial is lack of substantial documentation. The package is not well documented and articulated. And there are legal requirements that you have to try to put your case through those things. You meet those requirements, right? For example, the Danasa case. If you are submitting a national interest waiver petition, you better make sure you meet the 5-prong text, right? Beginning from the advanced degree or exceptional ability, move to the whether you are well positioned, national in scope, and also why a waiver should be granted. So that is one, usually lack of documentation. Secondly, what we have discovered is that the supporting letters, the testimonials that are submitted by some petitioners, do not link their personal situation to the national interest, and just like it prepared, like it's not a reference saying you're going for a job or you're seeking employment. It has to, yes, the letters have to be directed towards what you're doing and how that will be beneficial to the national interests of the United States.
Right. So it becomes there's a disconnect. So if you're the reviewing committee or the person, it's like, okay, all the credentials are here, everything is check, 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 check. Objectively, they're meeting and then you read the recommendation letter, and they didn't answer the question properly. Almost like they got they need a little bit of prompting, a little bit of coaching on not what to say, but how to frame it.
Yeah, what we do, we work with our clients and their potential reference to give them the background and what the law is looking for. Usually they just have to know that, because most of the time when they accept to do these letters, they already believe in what the petitioner is doing. The only error they make is that they don't articulate it sometimes clearly, which if you guide them and say, this is what immigration is looking for, see whether this petitioner has those things, and they'll be like, oh yes, I know this, I know this, I know this, I know this will do this, and there it is. So we don't really write it for them, but we guide them. Yes. Yeah.
From a practical point of view, what does the process look like? What should someone expect, from the point that someone decides to pursue an EB-1A or the NIW through filing and approval? Can you kind of summarize that process?
Yeah, roughly. I will give you roughly the USCIS procedural approach to this, how you should approach. Now, first of all, when you decide to file that, it depends on whether you are in the United States or you are abroad, and it depends on what immigration status you are in. If you are in the United States, you can file your what is called Form I-140, which is a petition for employment skilled worker, and you articulate that as a national interest waiver case or as an extraordinary ability case. You can file concurrently with a green card, with application for a green card, if you are in a valid non-immigrant status and you are in the United States. It can be very helpful because in that case, if you really qualify, you can file concurrently with your family members right from the beginning. However, you need to know that if it is not granted, the petition itself, the I-140, then the rest of the adjustment of status and all those things and the money you have spent, that will be lost.
Done. Yeah.
If you are out of the United States, you will end up filing just the same I-140 petition, but you will, if it is approved, you will come in through what is called consular processing because you are not in the United States. If and when that petition is approved, it will be sent to the State Department, to be sent to the consulate, and then you will be interviewed just for formality purposes to determine your eligibility and admissibility to come in based on that approved petition. However, both EB-1A and EB-2 national interest waiver, they do have priority, what they call priority dates. What this means is that the visas are not always immediately available. The State Department bulletin that comes out every week does indicate what categories the visas are available, because visas for employment-based, like some other visas, apart from some family-based immediate relatives, they are issued as they are used. There are a certain number of visas that are issued every year. But these two, immediate extraordinary ability, the visas are mostly always available. You can imagine these are high-end visas and they are scarcely used up. EB-2, national interest waivers, sometimes they are about 5-6 months delay on whether the visas are available. What this means is that your I-140 can be approved and USCIS, United States Citizen and Immigration Services, will tell you this petition has been approved, but the visas are not available at this time and you will be notified. The wait can be anything between 2 months to about 8 months. But at that point, you are happy because you have an approved petition, which doesn't really technically expire. It doesn't technically, yes.
Well, let's talk for a second. We've got just a few minutes left. Is there an example, like, a case that you worked that stands out because, someone successfully qualified and, there was something in particular that really made that case work?
Yeah, let me look at, yes, let me give you one on the one EB-2 national interest waiver case that we worked on not long ago. Was a young lady who graduated for about 2 years, master's degree, for having worked in hazardous wastes, and was working with an NGO. And we could demonstrate that she was well positioned to continue her endeavor in the United States, and her area of endeavor was national in scope. And also it was important and urgent that she doesn't go through the lengthy labor certification process to assist in this environmental hazardous waste situation.
Mm-hmm.
For extraordinary ability, I remember one of the last extraordinary ability cases we did, which was very fulfilling, was a scientist who was working in Switzerland, and he came from Africa. He was in a university in Switzerland. He finished his PhD program, but because his research attracted some professor in Harvard, he was invited to come to Harvard for 3 months to work on a stipend to work with that professor. And when he came to Harvard, he consulted us, and we found out that the area that it was, I believe it was epidemiology and some molecular biology thing, we found out that we could do an extraordinary ability for him. And we did it, and we did what is called premium processing. What happens is you can pay about $2,900 or more to get your petition adjudicated within 30 days or less. And we did that, and in less than a month, he got his green card. Actually, he's got his petition approved. He filed his adjustment of status for his kids in Switzerland and his wife. And in less than 6 months, they were all in the United States as permanent residents. So that was very, very fulfilling in the way it worked. He was going to go back to Africa, in a country which I would not mention, which was a war-torn country. But it's, so that was,
Wow. Yeah, that's got to be very satisfying in your work when things work out like that. And, because you're impacting families, friends, right? It's such a ripple effect. And do you find that, a lot of your clients are, do you find yourself working with one family member and then another family member in your work?
Oh, yes. Referrals and we work is very common, especially in my community and my area.
You end up getting to know all the family members.
Exactly.
That's great. That is great. Listen, man, we're up against time here, but I enjoyed our conversation, and thanks for sharing your expertise. I know we'll talk again soon.
Yes, thank you very much. And next time, I hope we can go into some more details and explore some of the options. Yes.
Absolutely. I'll talk to you soon. That's it for today's episode of U.S. Immigrant Journey, Opportunities and Challenges. If you'd like to learn more about your options or get guidance on your immigration journey, visit Edwin's website, foghamlaw.com, to connect with Edwin and his team. Thanks for listening. I'm Sean O'Connor. Do us a favor, leave some thumbs up, subscribe, maybe share a link with someone in your world who would benefit from this kind of expertise. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review.